London's surviving kite rule is not a blanket ban, it targets flying that annoys people using a public thoroughfare. The familiar claim says that flying a kite in London is illegal. The statute is stranger and more precise. Section 54 of the Metropolitan Police Act 1839 makes a person liable when, within the Metropolitan Police District, that person flies a kite or plays a game in a thoroughfare or public place to the annoyance of inhabitants or passengers. The words after kite matter. This is not a national ban on parks, beaches, or every patch of London sky. It is a Victorian public nuisance rule tied to location and effect. The same section groups kite flying with creating dangerous slides on ice or snow, ringing doorbells without lawful excuse, discharging fireworks, obstructing crossings, mishandling cattle, and carrying awkward objects along footways. Read as a list of absurdities, it sounds like legal clutter. Read as a description of a crowded 19th century street, it becomes an early attempt to manage competing uses of public space. The kite survives because the underlying problem, one person's recreation becoming another person's obstruction, never entirely disappeared. In 1839, London had no modern highway code, unified local government, or dense library of specialized regulations. Streets carried pedestrians, horses, carts, coaches, traders, performers, livestock, building materials, and children at play. The Metropolitan Police had been created only a decade earlier. Parliament's 1839 legislation expanded the police district and consolidated practical street order powers. Section 54 reads like a catalogue because the street itself was a catalogue. A hoop rolling along a footway, a plank carried through a crowd, a horse being shod outside a lawful market, or a kite line stretched across a route could each create a specific hazard. The provision did not try to define one abstract theory of urban nuisance. It named recurring conduct that constables and magistrates could recognize. Parliamentary debate in 1839 described the clause as gathering existing police rules together so officers and the public could find them in one place. The modern reader sees whimsical objects. The Victorian drafter saw traffic management before motor traffic existed. A 19th century kite was not necessarily a small toy flown from an open field. Kites could be large, made from paper or fabric over wooden frames, and controlled by long lines. In a narrow thoroughfare, the line mattered as much as the kite. It could cross a rider's path, startle a horse, entangle a cart, or force pedestrians to move unpredictably. The statute's language does not require us to invent a particular accident. It tells us the legal threshold, annoyance to inhabitants or passengers, or, for an adjacent ice slide offense, common danger. The law was not protecting the sky from color. It was protecting passage through a busy shared space. That distinction also explains why contemporary summaries that simply say it is illegal to fly a kite in London are misleading. A carefully flown kite in an appropriate open area is not what the words describe. The offense is conditional. Place, obstruction, annoyance, and the presence of other users turn ordinary play into the conduct the section regulates. Many technologies named in old statutes vanish while the social problem remains. Casks become delivery trolleys. Horse traffic becomes motor traffic. Street entertainments move from caravans to amplified equipment. The 1839 Act has been amended repeatedly, and parts of Section 54 have been repealed or altered, but the kite endgame language has endured in the current text. Its penalty is expressed through the modern standard scale rather than the original Victorian sum. Survival does not prove frequent prosecution. Laws can remain available while enforcement shifts toward newer, more tailored powers or simple police direction. The important fact is narrower, the provision has not been erased, and its conditional nuisance rule still forms part of the statute. Parliamentary debates decades after enactment openly treated the kite clause as archaic, sometimes citing it while discussing other street activities. A 1958 debate quoted the language directly while Parliament adjusted penalties elsewhere in the section. In 2014, peers again mentioned kite flying while criticizing the use of the same old provision against street performers. Those references do not create a new offense, they show lawmakers were aware of the wording long after the streets that produced it had changed. That legislative self-awareness is part of the story. Parliament knew the list sounded old-fashioned, yet the general task of keeping thoroughfares passable gave it continuing utility. Collections of weird laws often remove conditions, quote repealed provisions, or repeat jokes without checking the legislation. Section 54 is a useful test case because both exaggeration and dismissal are tempting. The exaggerated version says all kite flying in London is forbidden. The dismissive version says the rule is a fabricated Victorian myth. The official statute and historic parliamentary record support neither. The text exists. It applies within the Metropolitan Police District. It requires kite flying or game playing in a thoroughfare or public place to the annoyance of inhabitants or passengers. Those qualifiers are the law, not fine print to omit. A careful account also avoids claiming that modern police routinely search parks for kites. Publicly accessible sources establish the provision's wording and history more clearly than its recent charging frequency. The advertiser's safe lesson is not that London criminalizes harmless fun. It is that viral legal trivia becomes accurate only when jurisdiction, conditions, and current status are restored. Modern regulation often prefers general duties and flexible nuisance concepts. Traffic law addresses obstruction. Local authorities manage parks. Public order powers deal with threatening or disorderly behavior. Civil nuisance law balances competing uses of property. The Victorian list took a more concrete route: name the act, attach a condition, and give a magistrate power to respond. Concrete lists are easy to apply when the same problems recur, but they age visibly. That visible age is why the kite clause attracts attention while newer wording about unreasonable obstruction does not. Yet the old design has one virtue. Its condition protects ordinary behavior. The act does not say a kite is inherently wrongful. It says the conduct crosses a line when it is done in the specified public setting and annoys people using or living beside it. The statute therefore contains a miniature balancing rule, hidden inside a sentence about play. A city works because millions of people accept tiny limits on how they use shared space. A delivery can stop briefly, but not indefinitely. A game can be played, but not so that strangers lose safe passage. Noise can announce something, but not without regard for everyone living beside it. Section 54 tried to encode that bargain with the objects of 1839, horses, hoops, barrels, fireworks, doorbells, ice slides, and kites. Its survival makes the language look eccentric, but the structure is familiar. Context converts freedom into nuisance. Consequence, not novelty, is the point. That same logic now appears in countless rules about pavements, parks, vehicles, noise, and temporary events. The objects change more quickly than the need to negotiate shared ground. The accurate headline is therefore less comic than the myth. London did not declare war on kites. Victorian lawmakers wrote a street management rule for a city in which a line across a crowded road could be a real obstruction, and modern law never fully deleted that sentence. Nearly 2 centuries later, the kite remains aloft in the statute book, not because the sky is forbidden, but because the street below still belongs to everyone.